DOGE went to war against peace. The Institute of Peace, that is. Yes, somehow DOGE and the federal government went to war against the Institute of Peace, and they brought armed police officers. Yes, DOGE brought guns to a peace fight. You might have heard that in February, President Trump issued an executive order directing the dismantling of the 40-year-old Institute of Peace, which had been created during the Cold War to prevent war and promote nonviolent conflict resolution around the world. But the Institute pointed to the law that created it, which specifies that the Institute is an independent nonprofit organization, not an executive agency, and thus isn't under President Trump's authority. DOGE heard these arguments and decided to move forward with a hostile takeover anyway. Literally a hostile takeover with guns. And on March 17th, with the help of armed officers from 3 law enforcement agencies and 1 private security contractor, DOGE staged a dramatic physical invasion of the Institute of Peace's privately owned headquarters, the building in Washington, D.C. This culminated in the ousting of the Institute's leadership, the takeover of the organization's computer systems, and the takedown of the Institute's website. And of course, yet another lawsuit against the Trump administration. I'd like to come up with a pithy metaphor, but when you physically take over the Institute of Peace with armed law enforcement officers, I got nothing. But how did we get here? Well, in 1984, the United States Congress established the Institute of Peace to, quote, promote international peace and the resolution of conflicts among the nations and peoples of the world without recourse to violence. The act that established the Institute stated explicitly that the Institute is an independent, non-profit national institute. Now, over the past 40 years, the Institute has provided research, analysis, and training in diplomacy, mediation, and other peace-building measures. It has been on the ground in Iraq, Afghanistan, Pakistan, Colombia, and the Philippines. In Baghdad, for example, the Institute helped to reduce sectarian violence by conducting mediations between Sunni and Shia factions, imams from local mosques, militia leaders, and tribal chieftains. And when Congress created the Institute, it included several provisions designed to ensure the Institute's independence. First, Congress instructed that the Institute was to be run by a 15-member board, which would include 3 ex officio board members, the Secretary of State, the Secretary of Defense, and the President of the National Defense University, as well as 12 individuals selected by the President with the advice and consent of the Senate. The board must be politically balanced. No more than 8 members of the board can be from the same political party, and board members have specified terms and can only be removed by the President under the following narrow circumstances. 1, in consultation with the board for conviction of a felony, malfeasance in office, persistent neglect of duties, or inability to discharge duties. Or 2, upon the recommendation of 8 voting members of the board. Or 3, upon the recommendation of a majority of the members of the Committee on Foreign Affairs and the Committee on Education and Labor of the House of Representatives, and a majority of the members of the Committee on Foreign Relations and the Committee on Labor and Human Resources of the Senate. Now, provisions like these are often known as for-cause provisions because they mean that a person can only be removed if certain causal conditions are met. Most agency heads in the executive branch serve at the pleasure of the President and can be dismissed for any reason whenever the President decides to remove them. But employees who are appointed under a for-cause provision, though, have additional protections and can only be dismissed by the President if certain requirements are met. Usually this involves misconduct or serious illegal activities. These for-cause removal provisions are designed to ensure that some employees are sheltered from partisan political whims and able to fulfill their statutory duties, which often involve some kind of oversight or independent action. Now, despite, or maybe because of its mission of peace, the Institute has long been in the political crosshairs. In 2011, with a little help from Republican Congressman Jason Chaffetz and Democratic Congressman Anthony Weiner, Republican Representative Chip Kravac introduced an amendment to cut all funding to the Institute, claiming that the Institute's programs could be replicated by several other agencies, including USAID, another agency that has recently been dismantled by the Trump administration. But the Institute's importance was defended by numerous public policy experts and military leaders, including General Anthony Zinni, who served as a special envoy under both George W. Bush and Donald Trump, and said that, quote, Congress would be hard-pressed to find an agency that does more with less, and that, quote, the idea that eliminating the United States Institute of Peace would benefit taxpayers is extremely short-sighted and ill-informed. America deserves better from Congress than eliminating something that saves American lives and taxpayer dollars. And he cited numerous instances where the Institute's personnel had real impacts in conflict resolution and violence reduction. President George W. Bush also proclaimed the importance of the Institute's work at the 2008 groundbreaking for the building DOGE would later break into. And in fact, there were reports that the physical takeover of the building was simply because the building looks really cool. But he said, quote, the work of democratic development is the great cause of our time, and we shouldn't shy away from it. And we must be confident in our ability to help others realize the blessings of freedom. My big concern is that the United States becomes isolationist and nervous. We don't support those values that have stood the test of time. The Institute of Peace, I hope, will make sure that never happens. More recently, though, the Institute was the subject of a report by the Heritage Foundation, the same organization that spearheaded Project 2025, which we talked about at length in several of our videos. In a September 2024 Heritage Foundation report, the foundation urged Congress to defund the Institute of Peace based on the organization's supposed political bias and mission creep. And the Heritage Foundation offered a few examples of what it considered mission creep, stating, quote, "In 2012, the USIP broadened its mission again to include interpersonal violence, with programs to end sexual violence during wars and internal conflicts, and in 2013 conducted a symposium on men, peace, and security that sought to encourage nonviolent notions of masculinity in societies affected by violent conflict." Now, defunding an organization through a lawful act of Congress, like Heritage had recommended, though, would require the president to work with Congress. That would be totally legal. Congress could choose to defund an institute that it had previously decided to fund. But only Congress can decide that, since Congress alone has constitutionally delegated power to spend funds. And that's the kind of thing that happens in ordinary times. But we're not in ordinary times. So instead of asking Congress to defund the Institute of Peace, on February 19, 2025, President Trump signed an Executive Order 14217 titled Commencing the Reduction of Federal Bureaucracy, which recommended that the non-statutory components and functions of the Institute of Peace be eliminated to the maximum extent consistent with applicable law. But different people have a different definition of maximum extent consistent with applicable law. So armed with this executive order, DOGE did what it does best, executing a chaotic and possibly illegal takeover. Now, after President Trump issued his executive order mandating the dismantling of the Institute of Peace, DOGE wasted no time in moving in for the kill. The very next day, a representative of DOGE contacted the Institute. The Institute leadership agreed to hold a virtual meeting with DOGE several days later. In that meeting, representatives for the Institute, including its president, George Moose, and its outside attorney, George Foote, explained to DOGE that the Institute is an independent nonprofit organization outside of the executive branch and thus is not subject to President Trump's executive order. The Institute followed up with a letter to the Office of Management and Budget, the OMB, reiterating its independent nonprofit status, but offering to maintain a cooperative relationship with the executive branch as it always had. In early March, though, George Moose heard that DOGE was doing reconnaissance on the Institute's security operations, trying to determine who was the Institute's security contractor and strategizing how DOGE could physically invade the Institute's headquarters. And shortly after that, the Trump White House engaged in one of its signature moves, questionably legal, politically motivated firings. Via email on March 14th, the White House doubled down on its position that the Institute is under the authority of the executive branch, ignored the statutory provisions of limiting the president's ability to fire Institute board members, and sent emails to all of the Institute's board members except the 3 ex officio members, declaring that they were fired. The emails, of course, didn't include any justification for the firings because there was none. Now, shortly after those emails were sent, DOGE arrived at the Institute's building and tried to get in. But because the Institute, not the executive branch, owns the building, George Moose told the Institute's private contractor security team, Intercon, not to allow DOGE into the building unless DOGE had a court order, which of course it did not. When DOGE returned, they still didn't have a court order, but they did have several FBI agents. They presented the Institute's outside attorney with a letter that claimed that Moose had been removed from his position as president of the Institute. Then on March 16th, the FBI called and threatened the Institute's chief security officer, claiming that because he had denied DOGE access to the building, he would now be under investigation by the Department of Justice. And fearing that DOGE would try to strong-arm the Institute's security contractor, Intercon, the chief security officer recommended that the Institute suspend its contract with Intercon. The Institute followed this recommendation and revoked keycard access for Intercon. Unfortunately, the Institute leadership was unable to get back one of the physical keys that was held by Intercon's account manager. The next day, the account manager and several Intercon staff arrived with the physical key and entered the building, where the Institute's chief security officer and attorneys met them and told them that they were trespassing. The Intercon representative informed the Institute representatives that DOGE had threatened to cancel every Intercon contract across the government if Intercon did not let DOGE's representative into the building. Incredibly, Intercon staff then tried to get into the Institute's arms room where the guards' firearms were stored. At that point, the Institute's chief security officer and Institute president, George Moose, set the building on lockdown.
DC police showed up at my office and said, "It's time for you to go."
DOGE employees continued to try to access the building from the outside, at which point the DC police apparently arrived, and instead of assisting the Institute's original staff in keeping the DOGE team out of the building, the DC police held open the doors to let DOGE in. The DC police then escorted George Moose, the Institute's attorneys, and the Institute's chief security officer out of the building, not even allowing them to retrieve their personal belongings or cars on the way out. DOGE wound up calling in the FBI and the Department of State's Diplomatic Security Service police officers to assist with the takeover. And the next day, DOGE enlisted the help of an Institute of Peace employee in Georgia to help DOGE get into the Institute's information systems. Since then, the Institute's website has disappeared entirely. Now, if you steal an independent nonprofit's building, you'll probably want a good lawyer. But if you want a great lawyer, let my law firm, the Eagle Team, help. If you've gotten in a car crash, suffered a data breach, especially if you've got a data breach letter saying your information might have been leaked, or are dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, You need the Eagle team. Now, the Institute of Peace doesn't believe in violence, but it wasn't going to just capitulate to the Trump administration's bullying. Instead, the Institute's board members filed a lawsuit and asked for a temporary restraining order. And on March 18th, the Institute of Peace, along with 5 terminated board members, filed suit against President Trump, Secretary of State Rubio, Secretary of Defense Hegseth, National Defense University President Garvin, several members of DOGE, and the individual that President Trump had tapped to be the new Institute president. The plaintiffs asked D.C. District Court Judge Beryl Howell to stop the termination of the board members and the Institute president and to prevent DOGE from continuing to access the Institute's building and information systems. The plaintiffs generally argued that President Trump's executive order had overstepped his executive authority because the Institute is not an executive agency. Instead, it is a nonprofit organization incorporated under DC nonprofit laws. And by attempting to exert control over the Institute, President Trump had usurped the authority of Congress, which had created and funded the Institute and had explicitly designated it not as an agency under the executive branch, but as an independent nonprofit organization. The plaintiffs argued that President Trump had also violated the statute that created the Institute when he fired the board members without meeting the requirements for dismissal, and plaintiffs also asserted that President Trump and his 3 ex officio board members did not follow the correct procedures to remove the Institute's president, so they argued his firing was also illegal. And lastly, the plaintiffs argued that DOGE's invasion of the Institute's headquarters was an illegal trespass. They pointed out that the building belongs to the Institute itself, not the executive branch, and the building purchase was funded by private gifts and contributions as authorized by the statute. Therefore, DOGE's incursion into the building after being told repeatedly to leave was an illegal trespass. So plaintiffs asked the court for a temporary restraining order, or TRO. As we've talked about before, that's an extraordinary remedy which allows the court to issue an order without a hearing or the opportunity for appeal. And in order to obtain a TRO, a party has to demonstrate a likelihood of success on the merits, irreparable harm, and that the public interest weighs in favor of the TRO. Now, in their counter, the administration claimed that plaintiffs were unlikely to prevail on the merits because the institution is not actually an independent nonprofit. Instead, the administration argued that the Institute is part of the executive branch. They pointed out that the board is appointed by the President of the United States with the consent of the Senate, and because of this, defendants claim that the court doesn't actually have the authority to adjudicate a dispute between the Institute and the President, since both are within the executive branch of the government. And the defendants relied on the signing statement of President Reagan to argue that these statutory provisions that only allow for removal in narrow circumstances were not actually meant to limit the President's authority to fire board members. In Reagan's signing statement on the original 1984 U.S. Institute of Peace statute, President Reagan stated, quote, "I have been advised by the Attorney General that Section 1706F, relating to the President's power to remove members of the Board of Directors of the Institute, is neither intended to nor has the effect of restricting the President's constitutional power to remove those officers." Now, this was rather strange since a presidential signing statement has no effect and can't actually alter the plain text of the law, and the statute that created the Institute of Peace is clear about when a board member can and cannot be removed. But the administration also argued that while Congress can limit the grounds upon which the President may remove officers who serve quasi-judicial or quasi-legislative functions, it cannot limit removal for executive officers who perform only executive functions. Defendants argue that the Institute is more like the plaintiff in Myers versus United States and less like the plaintiff in Humphrey's Executor versus United States. So let's break this argument down. Now, Humphrey's Executor, which you might have heard in the news lately, was a Depression-era case that involved President Franklin Roosevelt's attempt to oust a federal trade commissioner. The FTC statute specified that commissioners could only be terminated for cause. President Roosevelt argued that this was an unconstitutional limitation on his executive power, but the Supreme Court disagreed, holding that the removal limitations in the FTC statute were permissible because the agency had quasi-judicial and quasi-legislative functions rather than executive branch functions. Then in its holding, the court relied on the specific functions of the FTC commissioners, which include making investigations and reports for Congress, a quasi-legislative function, and acting as an administrative judge, a quasi-judicial function. Now, the Humphrey's Executor Court distinguished Humphrey's Executor from the court's earlier case, Myers v. United States, which involved the removal of a postmaster. In Myers, the court ruled that the president could remove the postmaster in large part because the postmaster was an executive officer serving executive functions. As the Humphreys court said, quote, "He's charged with no duty at all related to either legislative or judicial power." Now, more recently in a 2020 case, Saylor Law versus Consumer Financial Protection Bureau, a divided Supreme Court considered whether the CFPB's structure was constitutionally sound under the parameters established in Humphrey's Executor. The CFPB is run by a single director who is appointed by the president for a 5-year term. And under the Dodd-Frank Act, the president could only remove the director for cause if the director demonstrated inefficiency, neglect of duty, or malfeasance in office. The court ruled that the president could fire the director at will, which means for any reason or no reason at all. And the court found a legal distinction between independent agencies headed by multiple members and independent agencies headed by single officials. Critics of the Saylor Law decision say there is little historical or textual support for creating a distinction between agencies headed by a single director and those with multiple members, though. But this was a victory for those who support the unitary executive theory of the Constitution. However, the decision did not overrule Humphrey's Executor, at least not entirely. The court reiterated that while the president does enjoy broad power to remove executive branch officials at will, there are exceptions to that power, including for, quote, a multi-member body of experts balanced along partisan lines that performed legislative and judicial functions and was said not to exercise any executive power. Which actually sounds a lot like the Institute of Peace. But the Trump administration argued that the Institute of Peace is more like the postmaster in Myers because the Institute does not have quasi-legislative or quasi-judicial functions. Thus, Congress had unconstitutionally limited the president's removal power vis-a-vis the Institute's board. And this is part of the administration's larger goal of undermining or even eliminating independent agencies. The Trump administration has previously fired the head of the Office of Special Counsel, the Democratic members of the Privacy and Civil Liberties Board, numerous inspectors general, and most recently 2 Democratic FTC commissioners. And all this is in the news recently because President Trump wants to be able to fire, hire, or not hire anyone even remotely connected to the executive branch. And many people are worried in particular because Trump has indicated several times that he wants to be able to fire the head of the Federal Reserve and install someone who will implement the interest rates that President Trump wants. And the Saylor law case is one of many indications that the Supreme Court is receptive to the unitary executive theory and will overturn Humphrey's executor on that basis when the question comes before them. So while that case is still good law now, it may not be in the future. And defendants also contended that the plaintiffs failed to meet another part of the TRO requirement because they had not suffered irreparable harm. Defendants argued that the worst plaintiffs would suffer, even if their firings were legally impermissible, was the inconvenience of being unable to serve their job functions for a short period of time. So Judge Howell, a famous straight shooter, was tasked with figuring out whether plaintiffs had met these strict requirements for a TRO. And largely because of the complexity of legal issues, Judge Howell declined to grant the Institute's request for a restraining order. While she expressed deep disapproval of DOGE's heavy-handed tactics, Judge Howell didn't feel like the Institute met the high standard for a TRO. Specifically, she wasn't sure that the Institute had made a legally sufficient showing that the Trump administration lacked authority to fire the board members and the Institute president. So while Judge Howell's order wasn't a victory for the plaintiffs, it wasn't a permanent defeat either. And this also highlights how extraordinary it is that judges keep issuing TROs against the Trump administration in other cases. It's a very, very high bar. Judges don't take it lightly, and the Trump administration keeps getting enjoined. But here, once Judge Howell had the opportunity to consider the full case on the merits, she issued a sweeping injunction reinstating the board members and repudiating everything DOGE did. Because remember, a TRO has a very, very high burden. It's emergency relief that's only temporary. A permanent injunction, while it takes longer to brief and to get the court up to speed, has a different standard. And Judge Howell ruled that the Trump administration's actions, quote, represented a gross usurpation of power and a way of conducting government affairs that unnecessarily traumatized the committed leadership and employees of USIP who deserve better. Now, the judge first determined that USIP was not part of the executive branch. Quote, instead, USIP supports both the executive and legislative branches as an independent think tank that carries out its own international peace research, education and training, and information services. As an independent entity exercising inconsequential government power and de minimis, if any, executive power, Congress's ability to restrict the president's removal power is even greater than that outlined in Humphrey's executor versus United States. So since USIP does not exercise executive powers and is not part of the executive branch, the president had no constitutional authority under Article 2 to remove the Institute's board members. Quote, the executive branch, per the Constitution, executes or administers the laws. Put plainly, that means interpreting a law enacted by Congress to implement the legislative mandate. Implementing the law through adjudications or rulemaking may also be considered executive branch activities. By contrast, purely investigative and information activities are not executive and rather fall into the same general category as those powers which Congress might delegate to one of its own committees. Apart from those core duties, the executive branch also wields significant power over foreign affairs, appointing ambassadors, making treaties, recognizing foreign nations, and engaging in direct diplomacy with foreign heads of state and their ministers. So after review of the factual record, Judge Howell found that USIP wasn't engaged in foreign affairs in the Article 2 sense of the word. Quote, USIP does not execute, enforce, administer, interpret, or implement any law. It does not make binding rules of general application or determine rights and duties through adjudication. It issues no orders and performs no regulatory functions. This was underscored by Section 4604, which gives USIP authority to do 10 specific activities, quote, all of which are related to the development and dissemination of information. USIP is permitted to create grants and do outreach, but only for the purposes of supporting research, promoting the study of international peace, educating individuals, assisting the Institute in its information services programs, and assisting the Institute in the study of conflict resolution, and promoting the other purposes outlined. USIP can serve federal entities as well, but again, only in these capacities, investigating, examining, studying, and reporting on any issue within the Institute's competence. USIP has no residual statutory authority to engage generally in foreign diplomacy or foreign peacemaking expeditions. The Trump administration argued that all activities activities which touch on international peace and conflict resolution are within the president's purview over foreign affairs. Judge Howell disagreed, though, stating, quote, "The executive branch does not control everything touching that subject area, contrary to defendant's suggestion. USIP's powers are not serving the executive branch's foreign affairs function. USIP does not wage war, conclude peace agreements, recognize foreign nations, establish foreign policy, make treaties, negotiate with foreign sovereigns for agreements binding on the United States, or transact with other states or maintain diplomatic relations on behalf of the government." Now, the Trump administration argued that by meeting with foreign officials, USIP engaged in diplomacy, which means the agency should be under his power. But Judge Howell found that when the USIP meets with foreign officials, it doesn't represent the United States government. Quote, "While defendants are correct that official diplomacy is quintessentially executive, they ignore that USIP acts as a completely independent, non-governmental organization when engaging with foreign groups. In fact, the value in having USIP organize and conduct trainings and promote peaceful resolution abroad is that USIP can do so without the burdensome bureaucracy and without carrying the sometimes controversial clout of the United States government. So since USIP is not an executive branch agency, the president does not have the right to remove its members at will. However, it's obvious that Judge Howell knows the government will appeal this decision, so she's also evaluated whether the outcome would be different if USIP were considered part of the executive branch. Now, this required her to engage with the Supreme Court's decision in SALA law. As the Trump administration acknowledged, even after SALA law, for-cause removal restrictions remain constitutionally valid for entities which have, quote, multi-member bodies of experts balanced along partisan lines, with staggered terms and duties that are neither political nor executive. And USIP's structure meets all of that criteria, according to Judge Howell. The USIP board is composed of members with relevant expertise, has bipartisan representation capped by statute, and features staggered term limits. But the Trump administration argued that to fall within the parameters of Humphrey's executor, an agency has to exercise quasi-judicial or quasi-legislative power. Since USIP has no judicial or legislative authority, Trump argues that Humphrey's executor does not apply. But Judge Howell disagreed. Quote, "The exercise of quasi-judicial or quasi-legislative authority was not dispositive to those decisions. Rather, those decisions use those terms to describe how the agencies were exercising something other than the core executive authority. The fact that USIP is exercising neither purely executive nor quasi-judicial or quasi-legislative authority here, rather exercising minimal to no governmental authority at all, means the reasoning of those decisions applies a fortiori. An entity does not become more subject to presidential control because it exercises far less overall governmental power of any kind. In contrast to agencies like the FTC and the NLRB that exercise quasi-judicial and quasi-legislative authority, USIP has no decision-making authority, authority to direct the activities of citizens through rulemaking, or authority to impact their rights or distribute their property. USIP, in short, is an institute of research and teaching, has far less authority, and is in far less need of executive control to promote political accountability and prevent unchecked exercise of governmental power." And finally, the court addressed President Trump's contention that he needed the authority to fire the board because they could impede his foreign policy agenda. Quote, "USIP simply does not exercise any executive power that the president needs to control at all." And Judge Howell said that the SALA law decision supported her conclusion and recognized the distinction between single-head agencies and multi-member boards. So where did that leave the president's termination of the board? Well, the court ruled that the for-cause removal protections provided under 22 U.S.C. 4605 were constitutional and remained in effect. As such, the president's actions were ultra vires and violated statutory law. Any subsequent actions taken based on those removals, including the firing of Ambassador Moose as USIP's president and the appointments of his successors, were also invalid. The court found in favor of plaintiffs on all related counts, including those asserting that these removals and appointments were illegitimate and void under the USIP Act. When defendants entered and took control of USIP's headquarters in March of 2025, they did so without lawful authority since the removal of the legitimate board and president had no legal effect. Therefore, the plaintiffs' trespass and ejectment claims were valid. It was illegal for representatives of DOGE and the temporary organization to enter the building. Judge Howell ruled that any property transfers executed by the unlawfully appointed leadership, including the transfer of USIP's assets to the General Services Administration, were invalid. And finally, the court granted USIP both declaratory and injunctive relief. Plaintiffs were wrongly removed and suffered irreparable harm, including the loss of their statutorily protected positions and the impairment of USIP's independence and reputation. Consequently, plaintiffs were entitled to full restoration of their roles and the nullifications of all actions taken by the improperly appointed officials. The issues presented by this case are novel. Here, Congress created a hybrid entity, part government, part charity. The Supreme Court has yet to weigh in on the legal ramifications of a hybrid entity. And hello, it is Devin from the future, and we seem to have gotten our answer on that last question, and it's not good. Just in time to rain on our parade, the Supreme Court has all but overruled Humphrey's executor, which will almost certainly mean that Judge Howell's ruling will be overturned on appeal. And of course, this will be appealed to the Court of Appeals and then the Supreme Court. Now, the case at issue is Trump versus Wilcox, which is a dispute about whether the president has the constitutional authority to remove members of certain independent federal agencies without cause. It centers on President Trump's attempt to remove Gwynne Wilcox, a member of the National Labor Relations Board, and Kathy Harris, a member of the Merit Systems Protection Board. Now, the NLRB and MSPB are independent agencies created by Congress. Federal law says their members should be nonpartisan, appointed to fixed terms, and protected from political firing. However, Trump fired only the Democratic members of the NLRB and MSPB, asserting that the for-cause removal protections unconstitutionally infringed on the president's Article II authority to oversee the executive branch. Now, as we talked about earlier in this video, overruling Humphrey's executor was a major part of Project 2025, and Trump has been methodically following the Heritage Foundation's blueprint, and his actions align with the unitary executive theory, which posits that the president should have comprehensive control over the executive branch. Now, Wilcox and Harris sued Trump alleging that their firings were illegal. However, the Supreme Court decided to allow the terminations to move forward on a procedural basis, which telegraphs that they are gutting 90 years of precedent in less than 2 pages, without the case being fully briefed. This litigation wasn't over the merits yet, it was simply whether there should be a stay pending appeal before the court gets to the full case itself. And the government asked for a stay of the lower court's order that reinstated the employees. The Supreme Court, however, decided procedurally on a preliminary basis that the stay should be in place, so the employees are as good as fired, and you would only do that if you were telegraphing what you were going to do on the larger merits case. And this is what we call a decision on the shadow docket. The shadow docket is a term used to describe the Supreme Court's practice of making significant rulings without full briefing, oral argument, or assigned opinion on these procedural issues. Now, the Roberts Court has decided more cases on the shadow docket than any court in U.S. history. Now, some reliance on the shadow docket is understandable and even necessary, since the court needs to respond quickly in emergencies. And, you know, there have been a lot of emergencies, especially when President Trump is the president. However, when the court overrules sweeping precedent without full briefing and public argument, it undermines the court's legitimacy and the rule of law. And here, the Supreme Court granted the government's application for a stay, effectively permitting Trump to remove Wilcox and Harris without cause while the case proceeds through the appellate process. And the court's conservatives cited the Saylor Law decision for the proposition that generally the president's Article II powers means that he can remove executive officers who exercise that power on his behalf without cause, except in narrow circumstances. And the court determined that the government faces a greater risk of harm from an order allowing Wilcox and Harris to continue exercising executive power than they face from being unable to perform their statutory duties. In other words, the conservative justices picked President Trump over the fired Democrats and over the law enacted by Congress. Now, overruling Humphrey's executor has far-reaching implications because it could apply to many other regulatory bodies. Like we talked about, the Federal Elections Commission, which is a nonpartisan independent agency with a similar board structure as the NLRB and the MSPB. And this decision means that Trump could probably reshape the FEC in future elections virtually overnight. The Supreme Court did not address the FEC calamity, but it did carve out an exception for the Federal Reserve, even though this case has nothing to do with the Fed. But as we talked about, President Trump reportedly wants to fire Fed Chair Jerome Powell. So the court summarily concluded that this decision doesn't apply to the Federal Reserve because, quote, the Federal Reserve is a uniquely structured quasi-private entity that follows in the distinct historical tradition of the first and second banks of the United States. And it cited to Saylor Law footnote 8. What is footnote 8 to Saylor Law? It said, quote, but even assuming financial institutions like the Second Bank and the Federal Reserve can claim a special historical status, the CFPB is in an entirely different league. It acts as a mini legislature, prosecutor, and court responsible for creating substantive rules for a wide swath of industries, prosecuting violations, and levying knee-buckling penalties against private citizens. And of course, it is the only agency of its kind run by a single director. Now, that brief footnote is directed to the history and structure of the CFPB and does not prove anything about the Federal Reserve. And I honestly have no friggin' clue about what possible history of the Federal Reserve would make it an exception to this general rule that the president can fire any one of these independent agencies. But what I can be sure is that the majority of the court just absolutely conjured that out of absolute thin air. And this 2-page decision did not go over well with the 3 liberal justices who all dissented. Justice Kagan said, quote, in valuing so highly in an emergency posture the president's ability to fire without cause Wilcox and Harris and everyone like them, the majority all but declares Humphreys itself the emergency. Justice Kagan excoriated the majority for its pronouncement that the Federal Reserve is exempt from the president's wrath, quote, except apparently for the Federal Reserve. The majority closes today's order by stating out of the blue that it has no bearing on the constitutionality of the for-cause removal protections for members of the Federal Reserve Board or Open Market Committee. I'm glad to hear it and do not doubt the majority's intention to avoid imperiling the Fed, but then today's order poses a puzzle. For the Federal Reserve's independence rests on the same constitutional and analytical foundations as that of the NLRB, MSBB, FTC, FCC, and so on, which is to say it rests largely on Humphreys. So the majority has to offer a different story. The Federal Reserve, it submits, is a uniquely structured entity with a distinct historical tradition, and it cites for the proposition footnote 8 of the court's opinion in Saylor Law, but sorry, footnote 8 provides no support. Its only relevant sentence rejects an argument made on the dissenting opinion, even assuming that financial institutions like the Second Bank and Federal Reserve can claim a special historical status. And so an assumption made to humor a dissent gets turned into some kind of holding. Because one way of making new law in the emergency docket, the deprecation of Humphreys, turns out to require yet another, the creation of a bespoke Federal Reserve exception. If the idea is to reassure the markets, a simpler and more judicial approach would have been to deny the president's application. The markets will like the bespoke Federal Reserve exception, but that issue, the president's authority to meddle with the Federal Reserve Board, was not the subject of this case. Traditionally, courts only decide actual ongoing controversies. Yet here the Roberts Court acted as a super legislature. So yeah, just as traditionally the Supreme Court is very reluctant to overturn precedent, but the Roberts Court seemingly has little respect for it. And a few days ago, Justice Roberts told Georgetown law students that the rule of law is under attack. Yeah, man, we're all trying to figure out who did this. And one of the effects of President Trump's all-out war on independent agencies is that now the CFPB has been completely gutted, and as a result, the CFPB killed rules that would have shielded Americans from data brokers. In fact, Russell Vogt, one of the architects of Project 2025 and the acting director of the CFPB, has canceled plans to more tightly regulate the sale of Americans' sensitive personal data. And never in the history of YouTube has it been easier to segue to today's sponsor, which is Incogni, which is a service which removes your personal data from online data brokers by reaching out directly and forcing them to take your personal info down. It'd be great to live in a world where we didn't need Incogni. Unfortunately, we do not currently live in that world. So at least Incogni thinks your personal data is important and fights on your behalf. If the data brokers resist, Incogni will take care of that too because Incogni fights back. And you use my link in the description or the code LegalEagle for an exclusive 60% off discount. Now, Incogni just launched a new feature called Custom Removals for subscribers to their unlimited plan that I think is really cool. It allows you to flag an unlimited number of sites where your data is exposed. And you can even have Incogni's privacy experts review and tackle the most uncooperative data brokers and people's search sites. Now, these data brokers are the reason why in the US, you can search your name and find a bunch of websites that will give anyone your home address, phone number, and extensive history. It's shocking just how easy it is to find all this information. It also might be why you're getting so many spam calls lately, or even how someone might steal your identity. But Incogni is a great way to take back control of your data, increase your online privacy, and cut down on those annoying scam calls and emails that used to flood my voicemail and inbox. Now, I've been using Incogni for years, and in the time you can see I've been on hundreds of lists, some of which had a high sensitivity score, meaning the broker had tons of data on me. Luckily, Incogni has completed hundreds of takedowns for me over the years and is processing dozens of others. If I were to try this myself, it would take hundreds of hours. So thank you, Incogni, for saving me weeks and adding me to over 40 suppression lists. And Incogni will continue to conduct ongoing removals because even if the broker removes your data once, they can collect it again. And Incogni makes sure your personal information stays off the market for good. So if online privacy is important to you, give Incogni a try. If you click on the link on screen or down below, you can try Incogni risk-free for 30 days and get a full refund if you're not into it. But if you do decide to keep it, you still get the exclusive 60% off discount, so long as you use my link or the code LegalEagle, all one word. So after you sign up for Incogni, click over here for more LegalEagle, or I'll see you in court.